Hi everyone. Thank you for joining us from different parts of the world. I think that also represents the panelists that are here today. We're all from different sites, and especially in this current time where everything has gone virtual, we really appreciate that you showed up for this panel, because it touches on issues that have been progressing over the years. It hasn't gotten to where we wanted to get to, which is why we're doing this reflection on where we've been, how things have moved, what that trajectory has looked like, and a way forward. So this event is part of a 2-week conference that is planned by civil society organizations. The main objective is to reflect on 3 decades of the steps that have been taken to secure women's property rights at divorce, separation, and annulment. I will do a quick introduction of myself and then the panelists, and we can jump right into the presentations. My name is Juliana Nnoko-Mewanu. I am a researcher on women, land, and property rights at Human Rights Watch. I do work mainly in countries in Asia and Africa, and look at issues around family law and how it's implemented, which results in possible discrimination on women and girls. So I will I'll introduce the panelists according to how they will speak. And bear with me, the bios have definitely been shortened. They're way longer than this, but given time constraints and given that we want to make sure that the audience has enough time to engage with the panelists, I have shortened them. So please, panelists, bear with me, and audiences, we hope you have a great time. Before I start, I would like audiences to write in the chat function, in the chat box, your name and your location and what you do. So kind of like an introduction as we're introducing the panelists. So I'll start with Seodi White. Seodi is a lawyer based in Malawi. She is a skilled organizational change and public service management expert, as well as a public policy expert who has provided direct advice on public policy and public law design to over 25 government policies and laws in Malawi. She currently is the Chief Director responsible for public sector reforms in the Office of the Vice President, Ministry of Economic Planning and Public Sector Reforms in the Government of Malawi. She is the technical lead in the public sector reforms agenda in the government and provides direct technical advice to the Vice President in the formulation and design, implementation, and monitoring of the government's public sector reforms agenda. Seodi is a women's rights activist and was previously a researcher with Women and Law in Southern Africa Research Trust, WLSA, through which she was involved in developing 3 groundbreaking laws aimed at achieving gender equality, namely the Prevention of Domestic Violence Act of 2006, the Wills and Inheritance Deceased Estate Administration Act of 2012, and Marriage, Divorce, and Family Relations Act 2015. Welcome, Seodi.
Thank you.
The next panelist I want to introduce is Jacqueline Ingutiah. Jacqueline, please correct me if I did not pronounce the last name. I'm pronouncing it the way a Cameroonian would pronounce
that's
it.
fine.
Okay.
It's fine.
I can make it more African if you need me to. just saying. Jacqueline is a human rights lawyer with over 15 years experience working on gender and human rights. Her particular interest has been engaging in interventions that promote the advancement of human rights for the most vulnerable populations. She is currently the regional coordinator at Kenya National Commission on Human Rights, a national human rights institution where she engages in protection and promotion of human rights through investigations, strategic litigation, and monitoring and reporting on the observance of human rights. This is definitely very dear to me because this is what I do. So thank you for your valuable work. She has extensive experience advocating regionally at the African Commission on Human and People's Rights and in Kenya for advancing women's rights to land and other productive resources. She is a member of several organizations, the Law Society of Kenya, FIDA Kenya, Chartered Institute of Arbitrators, and my favorite, she is a mediator under the Judiciary Court Annexed Mediation Project. Thank you for joining us, Jacqueline. Our next panelist is Sheila Minkah-Premo. Sheila is a lawyer based in Ghana. She is currently the managing consultant at Apex Lawconsult, a law firm in Accra that specializes in matters related to family law and land law. She is also a social justice expert and has carried out several projects on women and children's rights for several national and international organizations. She is a member of several women's human rights organizations, including Lawa Ghana. Lawa Ghana has been working on a legislative advocacy project since 2000 to ensure that the property rights of women in Ghana is protected with the passage of the Property Rights of Spouses Bill in line with Ghana's Ghana's constitution and specifically its Article 22. Welcome, Sheila.
Thank you.
Our last panelist will be Ambreena Manji. Ambreena is a professor of land law and development at Cardiff University in the United Kingdom. Prior to this role, she was seconded to Nairobi as the director of the British Academy's British Institute in Eastern Africa. This is between 2010 and 2014. Her research is focused on law and society in Africa. She has a substantial track record of publications in social science, arts, and humanities. Legal Journals Global Social Initiative. So I'm going to redo that. She co-founded the Law and Global Justice Center, which launched its Socio-Legal Journals Global South initiative in 2018 with writing workshops for early career legal scholars. Given her strong links with the African judiciary and legal profession, she initiated the African Feminist Judgments Project, which seeks to bring interdisciplinary insights to bear on African jurisprudence at national and regional levels. She recently published a book titled The Struggle for Land and Justice in Kenya. Welcome, Ambreena. So I see from the chat that we have a number of people from different locations: Alexandra from Brussels, Elizabeth from Kenya, Dennis from Kenya, I think. And a host of other people. Thank you for joining us. We really appreciate it. So we're going to jump right into it. I'm going to start with Seodi White. Given your substantive work in the area of women's rights, women's land and property rights, especially during your tenure at WLSA, can you speak on the legislative and your current position? Can you speak on the legislative and policy reforms, including litigations that have gotten Malawian law to where it is over the years in terms of protecting women's land and property rights? And could you reflect on the implications of the current general comment?
Thank you very much, Julia. And can you all hear me?
Yes, we can hear you very well.
Okay, thank you, Juliana, and thank you, colleagues. First of all, thank you very much, Sibongile, for inviting me to this panel. It's been a long time since we had this kind of conversation. It takes me back to all those years of hope, if I can call them that, whereby, yes, the law as it was not very promising, but we were very hopeful because we had come together as Pan-Africanist women to work together. So it's so nice. And even with participants, I've seen some colleagues, particularly some colleagues from Kenya, whom we worked with together. So it's so nice to see Clarice, Frances, you know, in all this. So nice to be here. Thank you very much. Anyway, the story is as follows, if I can call it a story. The story is that by the time we started working on this, our constitution had already been formulated, our democratic constitution had already been formulated, and that was in 1994. And there was a developing a conversation around women's rights, women's property rights, women, violence against women, and all that. That kind of conversation only started in Malawi probably I would say maybe 2000, 1998, 1999, 2000. That's when there was a strong conversation that was developing. So when we were at Women and Law in Southern Africa, when we were now examining the law as it was pertaining to women's rights, in particular to women's property rights, we found out that the Constitution itself you know, it guaranteed that everyone has a right to own property, either in their own right or if they want to in association with others. That was in section 28 of the same. And then in section 24, which is what I would call our section, because this is the one that refers directly to women's rights. Protection by the law and have the right not to be discriminated against on the basis of their gender or marital status, which includes the right to be accorded the same rights as men in civil war, including equal capacity to enter into contracts, to acquire and maintain rights in property, independently or in association with others, regardless of their marital status, to acquire and dispose land in their own right or in association with others despite any cultural dictates, and state that shall ensure that there is a gender equity in any law and land reform programs, to acquire and retain custody, guardianship and care of children, etc., etc. So you find out that the constitution as it was a very progressive tool. Now, when it came to the issue of property rights in marriage, which is what is zoning in at this present point in time, we looked at the issue of equal disposition of property. So it went on to say they also have the right to equal disposition of property that is jointly held with a husband. So at that time, the struggle, as you all know, was the interpretation that we all faced with in our courts about joint property. What is determined to be joint property? In our determination, when we looked at the interpretation by the courts of what that meant, it became very clear that there was an assumption of the fact that property in marriage is a separate entity until there's proof that it was owned jointly, either through joint purchase, receipts, etc. And this is where women were losing out. It was a very long battle, a sad battle, because you know, the courts at that time continued to really separate property and assuming that you know, it was separately owned, and the separately owned hurt women, as you all know, because of the economy of care. To this day, even then, women continue to be the carers of their homes. They're the ones who buy the relish and the food, and the husbands are the ones who buy the big things, the TV, the house, and etc. So the interpretation by the courts became a big debate. And this is when we were having this conversation with sisters around the world. And the Marriage Divorce Act at that time was also not very helpful. So there was a fight on equal fronts. How do we continue to define jointly held property? That was the issue. The definition, how the courts continued to create this separatism of jointly held property. in 2015, after many years of struggle, the courts came to, not the courts, the Marriage, Divorce and Family Relations Act was passed by Parliament, and it sort of made a different step, if I can use that language, with regards to interpretation of property. So first of all, it came very close to the current definition as per the general comment on what is deemed to be joint property. But when it said it came very close but far. What I mean is that it still put conditions of, it wasn't automatic that marriage, that property jointly held within a marriage is automatic. It talked about, certain conditions, which I'll come to just now. That still created, and I think to a large extent, still created a lot of latitude to the courts to determine, based on the interpretation of the court and not necessarily the clear letter of the law. And that's where we have been. But there has been, I tried to look for it, but I didn't find. There's been a case recently, which happened last month, where a decision based on the family relations, the family relations bill, it was a bill for a long time. I still think of it as a bill. The Divorce Act, that even a degree is considered to be family property. If you acquire your degree during marriage, there was a husband, a wife who had complained that she was being divorced after she had spent a lot of money in the care economy, as well as looking after the family, whilst the husband was pursuing his studies, a master's degree. And then because he found a better job after the studies, he wanted to leave the wife, among other things. And the judge took great exception to that and said, this is actually cheating. Your wife spends all her time looking into family relations and the care economy, and then at the end of the day, you find out that you are leaving her, so you've benefited from the marriage, and therefore any other benefits that will come by virtue of this degree also belong to the wife. So you can see that we've moved a long way, coming from where we were to the present moment when property was divided, like, clearly, and now we're even having an interpretation by a High Court judge saying a degree. I know, Jack, I know why you're smiling. A degree is, is part of family property just because of the efforts involved in supporting a spouse to sort of come up with that kind of a degree. So I said I would read to you how the new act defines property. So first of all, marital property, that is. So it says that, I'm reading, so if I look like I'm squinting, I'm looking for the section because I have it here. Just give me a second. Okay, yeah. Matrimonial property includes the matrimonial home or homes. So automatically the house becomes part of the matrimonial property. Household property in the matrimonial home or homes. Any other property, whether movable or immovable, acquired during the subsistence of the marriage, which by express or implied agreements between the spouse or by their conduct is used, treated, or otherwise regarded as matrimonial property. Non-monetary contribution means the contribution made by a spouse for the maintenance, welfare, or advancement of a family other than by way of money, and includes domestic work and management of the home, child care, companionship, the endurance of the marriage, any other manner or form of contribution that the court may consider appropriate. That is how the court has now gone into a definition of what it is called matrimonial property, not the court, the act. Now, what are the considerations that should be taken into account on the dissolution of marriage in the division of property? So I'm gonna slide down to the same act, and another second, and I'll be finished here. I thought it was very interesting. Distribution of property, section 74. Distribution of property upon dissolution of marriage. A court shall equitably divide and reallocate property upon the dissolution of the marriage, taking into account the income of each spouse, the assets of each spouse, the financial needs of each spouse, the obligations of each spouse, the standard of living of the family during the subsistence of the marriage, the age and health of each spouse, or the direct or indirect contributions made by either spouse, including through the performance of domestic duties. I would like to think that the full judgment of the case I've talked about also was mainly used under this section 74G to now come up with this decision that a degree could be deemed to be property of the marriage. The only difference with this act, and if you look at the Constitution, the Constitution talks about joint. The act is talking about matrimonial property. It doesn't talk about joint, it talks about matrimonial property. And then if the court, I would assume, was pushed to the brim to say what would be joint property, it would have to use the GC, I would believe. So that's what I've had to say. Thank you.
Thank you so much, Seodi, for giving us that rundown, especially in regards to the Malawian context. Just to provide a little bit of background for people who are joining, we're reflecting on the 3 decades of reform that has gotten us to where we are currently. And where we are currently is regarding the recent general comment on Article 7D of the Protocol of the African Charter on Human and People's Rights on the Rights of Women in Africa, so the Maputo Protocol. We're examining or reflecting on the implications for this general comment, which was adopted in an extraordinary session in February to March 2020. We're trying to reflect on what that means. How have things, I don't want to use the word progressed, but how have different countries taken steps towards reform to protect women's land and property rights, and how this general comment would either boost that process or strengthen that process. So just to provide a little bit of background for people who are joining, and we can make the general comment available to participants who are interested in reading the full comment. Next, I would want to go to Jacqueline from Kenya. Could you reflect on Kenya's journey towards securing women's land and property rights, particularly at dissolution of marriage? It would be great if you can give us a rundown of legislative and policy reforms, possibly litigation over the years. I mean, in a concise and brief manner. Let's make this a conversation, right? And in your perspective, how will the general comment advance women's land and property rights in Kenya?
Okay, thank you so much, Juliana. And listening to my senior Seodi White, I can actually understand where Malawi is coming from, because we have similar context on issues of matrimonial property. Allow me to go past 3 decades. I would want to start the conversation during the pre-colonial era. At that particular time, land and property was communally owned, and women then enjoyed their rights around the communal setup. And at that particular time, customary laws and practices were then used to address any disputes at that time. So when the coming of colonialism between 1895 and 1963 saw the imposition of several English laws into our system, and then that degraded the customary laws of the different tribes in Kenya. We have around 43 tribes, each with its distinct way of looking at issues. So yes, customary laws were allowed, but within a particular standard, that they ought not to be against morality, and they were not superior to the ordinances and orders of councils as was issued then. So that's where the problem began for women. We had a lot of laws imposed on Kenyans from the British and some from India, which did not conform to the local practices. And there's a wide breadth of research that shows from that particular time is when now many people started suffering vulnerabilities on issues relating to land rights. And for women, it became worse, because even the few rights they had within the communal setup, they no longer had it. So at a post-colonial era, that is between 1963 and now, allow me to talk about pre-2010 constitution and post-2010 constitution. So upon attainment of independence, we had the 1963 Lawconsult constitution, which I would say was not bad. For a start, as a country, it provided for right to property, and there was provision that was then section 26 or thereabout, that discrimination was not permitted. However, there was a clawback clause that discrimination was allowed in personal laws. So issues of divorce, separation, adoption, then customary law was applicable. And that continued over the years. We had a number of constitutional reforms from 1963, 64, up to 1991, when we had a major constitutional review, but still that clawback provision was maintained in the 1991 constitution. So outside the constitution, we also, the country at independence noticed that there were a number of laws and there was need to harmonize the laws so that they are within the context of Kenya. And one of the areas that was noted was on the issue of divorce, marriage, divorce, and succession. And the president around 1967 established two commissions. I'll focus more on the commission on marriage and divorce. So the commission did a fantastic job in going around the country, receiving memoranda from members of the public on what they would want the laws on marriage and divorce to look like. And that is when the conversation of distribution of matrimonial property upon divorce came about. The commission highlighted, documented very well, things that as a country we need to look into. And it came up with several recommendations. Particularly for this discussion, I'll go to recommendation 60, 62, and 138. Recommendation 60 talked about the need for married women to have same rights as unmarried women to hold property. Recommendation 62 focused on the rebuttable presumption that properties purchased in the names of spouses before marriage belong to them absolutely, and those that belong to each party as registered absolutely, and those purchased jointly then were to be held as joint tenancy. And recommendation 138, the commission suggested that we needed to give the courts the discretion, and here I'm underlining the word the discretion, because discretion has been used by the court over and over again, so that the courts needed to give discretion when dealing with matrimonial property disputes. And one of the things the courts needed to be guided with, allow me again to read, is customs of the parties. Number 2, contribution made towards acquisition and liabilities. And most importantly, the courts needed to look at equality. So that happened in 1968. Unfortunately, the recommendation and a draft bill, which the commission had come up with, a bill that had made provision for equality in polygamous union, separate property, protection of matrimonial home, very progressive clauses in that particular bill. They were unfortunately not regarded, and it continued. The report continued to gather dust, and though the one on law of succession was eventually succeeded, and we had the Law of Succession Act. So at that time then, as a country, we did not have any law that would then guide parties in cases to do with the division of matrimonial properties. And when the first case that was reported in Kenya on division of matrimonial property, that is I versus I, around 1970-71, that is when now the courts stated that the 1882 England Married Women Property Act was applicable in Kenya by virtue of the Judicature Act. So Section 17 of the Act allowed the courts to make determination on issues relating to possession of property. And again, I have to underline, it gave the judge discretion because it says, as the judge deems fit. So over the years, the court then started using the Married Women Property Act of 1882. They would give conflicting judgment on various issues, but looking at the various judgments over the years, there were certain principles that the courts set to guide other courts when determining issues of matrimonial property. So number one, the issue was on proof of existence of marriage. So parties needed to have proof that marriage existed. And that did not matter what type of marriage, even customary marriage, Muslim marriages were then allowed. There is one in the judgment of Nderitu versus Nderitu, the court actually mentioned that it is applicable, the Matrimonial Property Act is applicable at that time because the laws, the customary laws of the petitioners was not applicable then by virtue of new laws, and also by virtue that land no longer belonged to the clan. So the other principle the court set then was proof of dissolution of marriage. So properties were not being distributed if parties had not divorced. And again, there are decisions to that effect. Allow me to, when I'm quoting the name husband and wife, I know we are not supposed to refer to them as husband and wife because they are not supposed to be married, but for this context, for everyone to understand, I'll use the term husband and wife. So the other part is in appropriate cases, again, the discretion of the court, where property was bought joint by both spouses and registered only in the husband's name, resulting trust can be inferred. And where property is acquired during marriage and jointly registered, it is held in equal shares. That was the decision in Karanja versus Karanja. Number 4, it's that the property must have been acquired during marriage. That was something that was said. Properties belonging to limited liability companies were not considered matrimonial property by the virtue that limited liability companies were persons on their own right, different entities. And then the one that has really been, that has not really gone well for Kenya is on the issue of contribution. So the courts ruled that a wife's contribution to properties within marriage is an actionable right. So the court would then consider number 1, indirect contribution, and number 2, direct contribution. So there is a lot of judgments, decisions from the courts on what constitutes indirect contribution. So there's the aspect of household chores. That was then before we had the act. We had the issue of childbearing. And in Karanja versus Karanja, what the court took note is that even the wife taking care of other household duties by purchasing things in the house, paying school fees, that would then amount to indirect contribution. And then came the case of Kivuitu versus Kivuitu. I know the attendees from Kenya, this is a case that has been cited over and over again. So just a brief info about that particular case is that the High Court had awarded a wife 1/4 of the property, which was jointly registered with the husband because she did not prove contribution. But on Court of Appeal, the court set aside the orders of the High Court and awarded the woman 50-50%. And Justice Omolo in the ruling noted that it would be unfair for women of Kenya if non-monetary contribution is not considered during division of matrimonial property. So between the period of 1991 and around 2007, it was kind of automatic. In case of distribution of matrimonial properties, parties would get 50-50, regardless of whether they did direct monetary contribution. Then came the infamous case of Echaria versus Echaria. This has been widely reported across the world. In this particular case, the High Court had awarded a wife 50% share, just taking precedent of the Kivuitu matter, 50% shares of land that had been registered in the name of the husband. But on appeal, then the Court of Appeal decided to deviate from the initial precedents in Kivuitu versus Kivuitu and allocated 25% of the property to the wife. And this is what the court had to say. The woman was entitled to 25% of the property because that's the most likely presumption of her financial contribution. So that is when the court started demanding that parties who are claiming matrimonial properties then ought to have asked for matrimonial, they need to appear before court and prove that there was direct monetary contribution. And that continued from 2007. And a number of women, I am aware of a number of women who did not pursue division of matrimonial property just because of this decision. I am aware of advocates who advised their clients not to pursue division of matrimonial properties because of decision. So,
hello. I can't just a few minutes.
Hello? Oh, sorry for that. Yeah, so, and the good thing is that when judges were making this decision, they always called upon the Kenya Law Reform, the Attorney General, Parliament to have legislation put in place because even the courts themselves noticed that there is a gap. But there was a delay in that. One of the things that judges kept citing, including in the case of Echaria versus Echaria, is that the law that we are applying now, the 1882 law, has already been rendered obsolete in the UK. They have had numerous law reforms, and how come as a country we cannot come up with our own laws? So in 2009, the National Land Policy came into force, and it identified the gaps in the regime on matrimonial property and called for law reforms and the non-application of the 1882 laws and the need for legislation to have issues such as contribution and definition of matrimonial property. In 2010, we had a very progressive constitution that was promulgated. Article 2 provides for the supremacy of the constitution and the application of international human rights laws that Kenya has ratified. Article 45(3) provides for equality within marriage, and 68 of the constitution, 68C, calls for Parliament to enact legislation to protect matrimonial home and on issues that would deal with division of matrimonial property. So between 2010, when the Constitution was promulgated, and 2014, when the Matrimonial Property Act came into force, there was kind of a vacuum, but the courts were able then to fill in the gap. So there were cases where the courts ruled that the equality provision of the Constitution amounts to 50-50% in sharing. So we saw women still going back to court, and the court would award the 50-50%, and there are a number of decisions, Angela versus Jacob, CMN versus AWN, and in fact, the CWN versus AWN at 2013 decision, the husband had made 100% monetary contribution to the purchase and development of a property, but the courts equally said according to Article 43.3, it has to be at 50-50. Though, again, the High Court, you would tell from the many decisions in Kenya that there's been, there'll be a number of, you notice that a number of these decisions in court were not in line, they were conflicting with each other. So that has been the case over the years until we had the 2013 Matrimonial Property Act that defines matrimonial property, that defines defines contribution, both monetary and non-monetary, ownership of property, rights of polygamous persons in marriages. So I would actually say it's a very progressive decision, very progressive law. But the problem again that has marred this particular legislation is the issue of proof of contribution, especially non-monetary contribution. How then do you quantify non-monetary contribution? Number two, what form of contribution between monetary and non-monetary contribution has greater value? Majority of the decisions that are in Kenya show that monetary contribution are given prominence as opposed to non-monetary, with non-monetary getting around 30, 20, 40%. And the last thing would be on 50-50 share. Is 50-50 equitable share? And again, courts have given varied decisions as to whether 50-50 is equitable share. So to the best of my knowledge, there is a decision where currently there is a matter that is before the Supreme Court that is supposed to determine the issue of 50-50% and whether Article 43.5 is applicable on issues of matrimonial property. And I had a talk with the council on record for the appellant. Submissions have been filed, but no party, like amicus curiae or interested party, has joined in the case. And looking at the general comments, I say I welcome it. It has given wider interpretation on issues of matrimonial property. And as a country, we have done well. If you look at what the general comments suggest, we have done well, but we can do better in terms of the issue of equality and substantive equity. And I'm hoping these two principles, as provided for in the general comment, can be advanced in the Supreme Court case. Thank you so much.
Thank you very much, Jacqueline. For people who are just joining us, please feel free to introduce yourself, write your name, your organization where you work, and maybe the key things that you want to pull from this discussion. I'm going to go back because I feel like this general comment is so rich because it touches on different things. Jacqueline, you really brought out the whole dynamics around the matrimonial regime. So what type of matrimonial regime are people contracted in? How do people define equitable distribution? How do people define joint property? It's fascinating because when you get down to the technicalities, you need clarity in order to ensure that women are not discriminated against. I'm going to go to the general comment and just to refresh for people who are maybe not lawyers. I see some historians on the chat. I'm going to refresh people's memory of what Article 7 of Maputo Protocol, what it states. So it obliges state parties to enact appropriate legislation to ensure that women and men enjoy the same rights in case of separation, divorce, or annulment of marriage. It further states under sub-article D that they shall ensure that in case of separation, divorce, or annulment of marriage, women and men shall have the right to an equitable sharing of the joint property deriving from the marriage. We've talked a little bit, Seodi mentioned the distinction between joint property and what that means for division of property in terms of equal shares. Ambreena asked a question concerning court discretion, and we'll come to questions later on, but I was just trying to pull these threads that in each country we're seeing courts trying to determine what it means for couples to be in community, in property, joint property, separate property, and in ways that if we're not careful, women will end up losing out. The general comment also defines what these different property regimes would look like. It defines full community of property. It defines joint property deriving from marriage. I think the equitable distribution of property definition is important that we read out here. It is the apportionment of matrimonial property in excess of half of the property on the basis of awarding matrimonial recognition to both the unequal enjoyment of property rights that the woman endured during marriage and the non-monetary contribution of the woman to the household and the family. So this is equitable distribution would be more than half in the way this is written out. I like the fact that the general comment goes into the discussion about how women have, women's capability of earning an income has changed over time, and how women still provide the same types of non-financial contributions to marriage, and so pushes that point a little further that maybe we should be thinking about the fact that women are actually contributing more into marriage. I'm trying to put some fillers out there for what you people think about this. I'll move on to Sheila, who comes from to us from Ghana. Sheila, I wonder if you can put on your video and unmute yourself so our audience can know that you're next. Thank you so much. So
thank you very much.
We've gone through.
So I'm Sheila from Ghana, and I'm thankful to be part of this important meeting to discuss issues related to women's property rights. So with regard to Ghana, we've also it's been a very long journey. Like the previous speakers before me, we've had our political history, has been such that we live in a plural legal system in Ghana. And at independence in 1957, we had customary law coexisting with statutory law. So when it comes to the issue of marriage, customary law has always been recognized in our laws, even up to today. We also had some religious type laws, which is the Islamic type of marriage, which is also recognized up to today. And then we had the ordinance or civil type of marriage, which is currently known as the Christian and other marriage. So the way in which property rights were handled by the courts for a long time, depending on the particular regime. And basically, we also came from the history of separate property sort of principle where the court will look at the personal law of a person and then determine how properties were shared. In 1971, we had the Matrimonial Causes Act of 1971 enacted, and this particular law was enacted to regulate the dissolution of marriages under the then marriage ordinance, or the civil or Christian marriage I mentioned. But there was a provision in it which says that if you're married under any other law, at the dissolution of a marriage, you can also use this law to distribute, to deal with issues relating to property. The problem with the Matrimonial Causes Act was that it just simply said that at the dissolution of a marriage, the court will go into property rights and determine whether property in the name of one person, in reality, the other person also had an interest in it. And principles, as has been indicated out there, which is issues of equity, resulting trust, etc., were all put in there. My focus is on what happened in 1992 when we had our fourth Republican Constitution. A clause was put in there clearly indicating that our parliament was supposed to come up with a law to regulate the property rights of spouses. So it says in Article 22 of our Constitution that Parliament shall, as soon as practicable after the coming into force of this Constitution, enact legislation regulating the property rights of spouses, and with a view to achieving the full realization of the rights referred to in clause 2 of this article, a spouse shall have equal access to property jointly acquired during marriage, and assets which are jointly acquired during marriage shall be distributed equitably between the spouses upon dissolution of the marriage. So our Constitution called for equitable distribution of property, and it also called for legislation to be passed as far back as 1992. So in my organization, one of the organizations I work with quite closely, Ghana, we had a legislative advocacy project. And our interest was in pushing to have legislation passed, what we call the Property Rights of Spouses Bill, passed, which will ensure that this equitable distribution, which is indicated, was actually realized. We work with others and have had a bill, that we've been, trying to push since 2008. It went to Parliament, elapsed. It went again to Parliament in 2009, and then in 2013 it also went in. What I find interesting is that most of the things that we see in the general comments are reflected in it. It talks about jointly acquired properties being distributed equitably between the parties. It talks about contribution being both monetary as well as the things that people contribute, non-monetary contribution, including things that people do at home to help with the family, etc., etc. So all these things were in it, and we thought that if that law was passed, it would bring some kind of uniformity and clear principles by which the court would act. As I indicated, the courts were already using the equitable principles to ensure that women were being given, fair shares of property. Like I indicated, this law, as of now, has not been passed. But what happened in Ghana is that our Supreme Court started applying the constitutional principles directly. So we have a lot of cases from our Supreme Court in particular, which is now precedent in the country, where the courts have come up with what they call the equity is equality principle. And therefore, once it's established that some properties were acquired in the course of the marriage, the courts have been able to share it equally amongst the parties. Because it is judge-made law, sometimes depending on the circumstances, things are tweaked around a little bit. So we still think that there's a need for clear legislation to regulate property rights of spouses at divorce. One of the problems that our parliamentarians had with this law was the inclusion of a provision that cohabitees, that is people who had lived together and held themselves out as husband and wife, and none of whom is married under a law which prohibits a second marriage, and who have lived together for over 5 years, to also use the principles in the law to get a fair share of properties which are acquired. Our parliamentarians didn't want to see a law passed with that particular provision in it, because they said the constitutional provision which is being actualized in the law talked about spouses, so they married. So that's one of the things which, according to them, held up this bill from becoming law. The last draft of the law bill that I saw was in 2017, and they've actually removed the part to do with cohabitees and their right to enjoy the rights in this particular law. So it was intriguing for me to see in the comments that they've stretched spouses or those who can benefit from it to include people who are cohabiting. Another interesting thing I wanted to share, as far as Ghana is concerned, is that even though the full text of the Property Rights of Spouses Bill has not become full law, another law that just got passed in July of this year, which is called the Land Bill, actually has added provisions from the Property Rights of Spouses Bill and from the Constitution in this law. And therefore, whilst we're waiting for the full Property Rights of Spouses Bill to be enacted, we believe that there are provisions in it which will ensure that women enjoy their property rights irrespective of the type of marriage they are under. For instance, Section 11 of this new law, which we also helped to lobby for, it prohibits discrimination in practice when it comes to land. So customary practice, whether it's a customary law or anywhere, you can't discriminate against a person when it comes to land, on the ground of gender in particular. Again, Section 38 of this new law says that when people are going to register an interest in land, one of the requirements in the form that's going to be created for registration will be to find out the person's marital status. Once it's established that a person is married, then it will be presumed that the property belongs to the spouses. So there's a presumption, and you have to rebut it by additional evidence. Again, there are also restrictions in Section 47 to the transfer of land by a spouse. That is, land which is, or land or property which is acquired in the course of a marriage cannot be transferred without the written consent of the other spouse. That is also a protection, because we have a lot of cases in Ghana where properties which are jointly acquired get sold without the consent of the other party. So in the law further indicates that in an application for registration, once once it's established that you're married, then the marriage registry have a right to issue 2 certificates in each party's name. One of the challenges we're going to face with this is because we have 3 different types of laws which regulate marriage in Ghana, which are equally recognized, and 2 of them are potentially polygamous, which is the Islamic type of marriage and the customary marriage are potentially polygamous. The issue is how this would apply when it comes to people who are in multiple unions. In the Property Rights of Spouses Bill, we had made provision for people in multiple unions, which, if it had been adopted in this law, would have brought some kind of equity. And in the sense that we had designed a provision which would ensure that the ones who came into the property earlier, who came into the marriage earlier and helped contributed in acquiring maybe the initial property would be co-owners with the male spouse. And when other persons come in to the marriage as well, then that person will still have an interest in any new property which is acquired, but the ones who come in later will not have any interest in property which was acquired before they came into the marriage. It's a bit complicated, and I think that as we are talking within our context in Africa, we have to look at such issues, which itself brings some form of inequity. So, and the I'd like to raise is that the land bill, for instance, was something which was pushed a lot by the World Bank in terms of lessons learned. So you could see it was pushed by the World Bank. There was a lot of money in lobbying for it, and it was seen as, in the whole design stage, etc. I happened to be serving on the working group that helped with the bill, but there were a lot of men. There were more men on it than women. So you can see that you really need, if sometimes when a bill is perceived to be a woman's bill, sometimes there's this pullback. So I think one of the lessons we learned from this particular process is that if we have the resources to push forward with the bill, again, we would have to strategize in a much better way. Secondly, I think that the comments, I realize that they have indicated that when countries are reporting, one of the things we would have to report in will be on the legislation that they have put in place. So I'm hoping that the African Union, through the Commission, etc., would help our individual countries to be able to push to have clear legislation in place to protect women's property rights, particularly with regard to landed property. Thank you.
Thank you, Sheila. I have a follow-up question that I think just builds on what you were saying so far. Kate from the University of Birmingham in the UK wanted to, you just touched on some of the things that she wanted to understand on changes in family law in Ghana. And she also wanted you to expand on the women's mobilization behind the change. You talked a little bit about that. Could you give us a hint of how many different women's organizations were involved in doing this type of policy advocacy?
Okay, thank you very much. For the Property Rights of Spouses Bill, the organizations that were very key in it is, I mentioned Law Ghana, which was very key in pushing for it. We also have the African Women Lawyers Association, which is also another women lawyers group that was also interested in pushing for this law. Then we have a network, we call it the Network for Women's Rights, was also sort of a partner. The issue is, I think most of the problems we had was with regard to sustained funding. to sustain the work that we're doing on the bill. And so for me, in terms of lessons learned, I would say that that has been one of the challenges. At a point, we set up a coalition. We, Lawa spearheaded a coalition in pushing for this law. So we brought in other NGOs as well. Lawa and then the Lawyers Association, the key organizations. But we did set up a coalition. But I think that there are a few challenges that we had. We actually did a lot of lobbying, went to parliament, met parliamentarians, took them through the law, we did a lot of things to try to push it. But as I said, then the Ghana Bar Association also has a Women and Minors Rights Committee, which I'm also a member of. So we also added our voices to the call to ensure that this law was passed. And like I said, it's kind of stalled. So it has not been passed yet. But on the other law, which is the land bill, which I said just became law in July this year, it was mainly a government-led initiative. Okay, the Ministry of Land there was a big land administration project, which was funded by the World Bank and a few other major development partners, the British government, quite a number of them. And in the documentation, it was also based on Ghana's land policy, which had the land policy had indicated that there was a need to address the issue of land administration in Ghana, and to try to make sure that it is, gender issues are addressed, and also to try to ensure that when it comes to management of land, it's done in a better way. In Ghana, we have a peculiarity in Ghana. Most lands in Ghana are held by various customary means. That is, research shows that 80% of lands in Ghana are held through various customary means. That is, it's owned by either traditional authorities, owned by families or clans. Only about 20% is held by the government. So the way in which the customary landowners manage land is very, very key and has had an impact.
Thank you so much, Sheila. I think we're seeing some clear threads here. I know, Jacqueline, you didn't mention it, but there's also a lot of concern around spousal consent on transfer of property that's acquired during marriage. Because I did work recently in Kenya, I do know that there's been some slight amendment in the Land Act, and there's a technicality there that's really interesting and gives, you need to pay attention to these changes in law for you to be able to use it in a way that one spouse or the other is not left out. So I really appreciate that you brought up the spousal consent issue. I want to pause and take the pulse of the audience. We mentioned, Sheila mentioned cohabitees. I think this is a thread across Africa where we're seeing law that doesn't protect necessarily cohabitees. In some cases, I think in Zimbabwe, there was a move to protect cohabitees. Given that most of your countries are actually common law based countries, you would expect that common law marriage would be an actual progression that covers or protects cohabitees who get into these relationships, but actually with no formal document that has been signed, or their marriage is not registered, and there's no traditional ceremony that makes that marriage. I would be interested to hear from the audience, if at all you're interested in this type of topic, to type in, let us know what your views are on cohabitees, common law marriages, what types of protections should be awarded to people who are involved in these types of marriages. And I think the general comment does mention this. It talks about the fact that Maputo protects marriages that are registered. And so in some sense, marriages that are not registered kind of fall outside of this. And in these situations, the spouse with less power could be discriminated against in terms of how property is divided, or if they can even claim part of the matrimonial property. So I think these are very interesting threads and very interesting issues that have been brought out. Our next panelist is Ambreena. We would want to understand what are the possible levers for change given the new general comment. Give us a taste, a flavor of the wider context for women's rights, including pushback on other issues like reproductive rights that we have to be aware of. How can we ensure law reforms seen as connected, for example, land law, marriage law, inheritance law, so that they can all work together in a manner that's more, there's more synergy in how this is. And if possible, give us some concrete examples. I know that in the case of a number of countries, the countries that some of our panelists are in, there isn't that synergy between the different laws. It's seen as separate entities. And so at the end of it, it creates a degree of ambiguity and confusion when it has to be implemented. So we'll be very interested in hearing your take on this.
Thank you very much, Juliana. Let me, and thank you very much for the invitation to be here. It's great to be with you all, and thank you to Sibongile for the invitation to have a bit of a reunion amongst us. Let me start with that last point and work forwards, if you like. So the first interesting question, I think, is the question of how, and we've seen this thread come up in the discussion so far in what Juliana said, in what Jacqueline has said, what Sheodi mentioned, that we need to think beyond the way in which we're taught law subjects in law school, if we're to organize ourselves sufficiently to try and make progress on change on women's property rights. Let's put it as broadly as possible, on women's property rights. And I say that because what we have seen over, say, the past decade and a half of land law reform on the continent is that we will always be on the back foot unless we can make the argument that the different spheres of law are very much interconnected, so that there is no point, and we saw this really very early on, for example, in Tanzania in the late 1990s, there is absolutely no point in beginning a process of land law reform unless you're keeping a very close eye on what the implications are for other areas. So what are the implications for inheritance law, wills and probate law, marriage law, family law more generally. So in other words, what I'm getting at here is that although law schools discourage us from thinking in this way and expect us to study family law separately from property or land law separately from trust law, we need to make the argument that actually we need an overview of all of these different areas if we're to make progress, because otherwise what happens is that something that's given with one hand is taken away with another. So the interconnectedness of these areas of law, and what hasn't been mentioned, except maybe in just being briefly alluded to here in relation to consent, what we haven't discussed so far is mortgage law. So that, you know, there is also a threat to women in how land is dealt with during the subsistence of the marriage. So it's not just a question of what happens to a woman when the marriage is dissolved, or how a woman loses out in inheritance when her husband dies, for example. But also we know that whilst a marriage is subsisting, land, for example, can be dealt with, or the matrimonial home can be dealt with in ways that pose real threats to women, for example, in relation to mortgage. So mortgages, land being used as leverage for loans. And we know that if we haven't got strong systems for ensuring consent by women, that is one key way in which they can also lose out. And I'm not thinking here just of, you know, wealthy people who have extensive property on which they want to acquire mortgages. This is also true of, you know, small, what in the Tanzanian context was called small small borrowers. So when Patrick McCausland was working on land laws in the Tanzanian context, he referred very much to this question of trying to give protection to small borrowers and the spouses of small borrowers, to make sure that there was some protection for women, so that the banks had real duties to do diligence and to make sure that the proper consent of women and the understanding of women as to what a mortgage entailed and what the risks were was communicated. And what he came up against was significant reluctance by the banks to do this. So at the time, he was working in the late 1990s in Tanzania when the land laws were being drafted. Patrick McCausland was the legislative drafter, wanted to put in a clause that would protect women against large banks effectively lending to men without proper consent and understanding of spouses. And he came across real resistance by banks. And this is a sector we haven't really talked about here. We have to, I think, map out who are the actors in this constellation. And one of those is definitely the banking sector. The reluctance of, for example, a very large South African bank to accept a clause in the Tanzanian legislation that gave this protection meant that in the end, the South African bank went to the Tanzanian government and said, if you agree to such a clause being included in your land act, we will simply not invest in Tanzania. We will not bring this large South African commercial lender to South Africa, to Tanzania. This is how powerful they are. There are people behind the scenes here really influencing how the land legislation looks so that it works in their interests. We have to see that, and we also have to see at the same time that simply reforming land law is not enough. That in that context, we also needed to do something about marriage law, inheritance law. And in Kenya more recently, I think that has been, and Jacqueline alluded to this, that has been a problem because we had a new constitution that required us to pass land legislation within a defined time. There was a constitutional mandate on the timelines, but not so on family law or marriage law. So there was then a lag until we could get the family law stuff done, if you like. And that lag time is dangerous for women. And so I think one of my observations from watching this area for the last, say, 15 years is to say we really need to start joining up these areas of, our kind of traditional legal subjects in ways that we're not necessarily encouraged to do as legal practitioners or as law students. Really important to work, in other words, across these different domains. What I would say about my reading of the general comment is that there is, I think, really interestingly, a great focus on the domestic legal framework, which means that we can push internally in our own jurisdictions for change, but that we need to keep talking to each other in a Pan-African way of organizing to make sure that we are learning from each other. And so this is why I think the role of the amicus is so important. The amicus brief seems to be one of the great kind of Pan-African innovations of the last few years, is that you have interventions by different groups across the continent in each other's interesting formative law cases. So we need to work domestically, but think continentally and work continentally for certain. We need to, I think, do what we can to see how the general comment takes the threat of dispossession of women very seriously, and we need to look at what it says about how we implement legal reforms. And so it does stress that simply passing the law isn't enough, that the implementation of those laws needs to, you can't take your eye off that. The implementation stage is crucial. And there again, we will meet barriers and we will meet pushback because we know that once you implement a law, the street level bureaucrats who have to actually, once you pass a law, the street level bureaucrats have to implement that law, can play all kinds of games to make sure that it doesn't do the job it was designed to do. How do we make sure, for example, that the state reports that this general comment of the Maputo Protocol requires allow us to push certain themes and topics and issues? So how do we make sure that we are reporting and publicizing this idea of the recognition of women's non-monetary contributions to marriage, for example? What are the mechanisms for doing that? And then similarly, what are the mechanisms, now that we have this general comment, for engaging with things like capacity and training? So how do we engage in making certain that we are involved in some capacity in judicial training? Because it seems to me that we've seen this in all of the discussions so far. Jacqueline has said it, Sheodi has said it, Sheila has said it, that the discretion of the courts is still a hugely important issue. The courts wish to have discretion, but their having discretion involves and means that the court's way of thinking about these issues is critical, and we need to be able to influence it as feminists. So how do we get involved in, if you like, feminist judicial training? So that's my first point, is the interconnectedness of these different areas of law that we've been talking about. The second is to say something about the wider context, and I've already alluded to this, because I think there are dangers and there is a wider context we need to pay attention to. So on the one hand, again, a bit like Juliana, I don't want to use the word progress, but this general comment is, I think, really useful and progressive. But the wider context is not. The wider context for women's rights at the moment is not helpful to what we are trying to achieve. So we know, for example, that there's been a huge pushback on key related issues. Again, it's this question of what are the related issues that sit, that are kind of next to us in the area that we're working on, say property rights. There is serious pushback in some of those areas. So there's massive pushback against reproductive rights, for example. And if you take that seriously, if you look at the campaigns against women's autonomy and women's reproductive rights, and if you take that as seriously as it should be taken, then you will see that some of the gains in the Maputo Protocol could very quickly come under threat. So what I think the protocol does really well is it takes traditional conceptions of marriage and it kind of challenges them, so that it starts to recognize women's non-monetary contribution. It starts to say, there is such a thing as women providing, for example, reproductive labor, what you might call care labor in the home, alongside productive labor or instead of productive labor, and that is a form of contribution that should be recognized. Now, that is a progressive move, and that is good for feminists who want to argue that certain rights should follow as a result of those forms of work that women do, looking after children, taking care of the elderly, taking care of the sick, reproducing culture, all of those things that we would want recognized as forms of work. The Maputo Protocol seems to be suggesting backing us up. On the other hand, you have a very strong conservative movement on the continent now, which would precisely want to put women back in the box on that topic and to say, well, that's natural, that's what women do. Why on earth would it need to be recognized or compensated in any way? And it's that battle, that the wider context here is that battle between about conceptions of marriage, between the traditional conception of marriage, which says this is what women do because it's natural and it doesn't need to be compensated or even recognized, and the more progressive model that we're trying to work with here, which is to say non-monetary contributions as well as monetary contributions need to find their recognition. And I think we have to be alert to the possibility of serious conservative pushback on this issue. And the other danger, and it's one I'm starting to think about a little bit more now that I'm thinking about the wider context, is I think there's a real danger that there's a wedge that could be that can be utilized, inserted between women in the women's movement. And that is the wedge that can be, I think, inserted between propertied women, middle-class women, and non-propertied women. And I say that because what we know is, for example, the example of Uganda is a very good one. When Uganda was talking in the early 2000s about the possibility of spousal co-ownership of land, who was it who was resistant to that idea? Middle-class women, because they had acquired property in their own right, and they were damned if they were going to let what they saw as lazy, good-for-nothing husbands get hold of their property, right? So you have middle-class women's interests there, really powerfully being articulated in the public sphere. And my worry is that those women have their own self-interest in blocking reforms, which would actually be beneficial to non-propertied or working class women. And I think that we know that wedge exists, that difference exists, but I think that so do conservative forces, and that it's very easy for conservative forces to utilize them, because it's often, you know, middle-class women who buy into this whole kind of conservative model of, you know, the proper wife and her proper place in a reproductive home, in a, you know, heterosexual marriage, etc., etc. You know, the proper wife, that model. So I think we need to be very careful of that. In other words, that we mustn't get, we mustn't take our eye off the class issues here, and the possibility that middle-class women who have acquired property in their own name can be split off from the wider movement because they don't see their interests as aligned with other women. They see their interests as actually kind of against men as property owners, and they don't see their interests as aligned with working class women or propertyless women. So that's the wider context, and I think it's one we should be really conscious of. And that brings me to the final point I want to make, which is, you know, what are the possible levers for change? And I guess that comes back to this question that Juliana asked at the beginning, which is, you know, what is it, where is it we want to get to, I guess? And I'd like to hear more from the group of us and from the audience about this question. Where is it we want to get to? Now that we have this general comment, where do we think we should be going next, and what is it that would be an ideal target for our work in terms of securing women's access to property and securing the recognition of their monetary and non-monetary contribution within marriage. What this general comment does that I think is very useful is that it throws open and recognizes explicitly the work that women do in reproduction as well as in production. So it recognizes and explicitly states that women do important work in the home, in the form of caring, taking care of families, children, the reproduction of culture, all of those things. And that recognition, I think, is really important, because it gives us the opportunity to argue for a widening of the court's, for example, if we're in that context, the court's understanding of what constitutes a contribution by a woman. That's really important. There's a line of cases to be aware of, and I think, I don't know of other jurisdictions, I know the Kenyan case law. It's a line of cases in the past since 2000, well, they go back away, but the ones I've been following since the Constitution, a line of cases in which the courts are finding themselves debating, this woman has provided this work in the home. She's now claiming property. But what was the original reason for her being in that home? Was she an employee? Did she come into that home because she was originally, for example, a housekeeper? Or did she come into that home because she was a caregiver or a nurse? There's been a case just in the last few days reported. Did she come into that home, look after a man because she was his carer, and is now claiming the rights to property as if she were a wife? right? And you see the courts really, really working hard to police this boundary between wife, not wife, or wife employee, right? That I think is really, really important. What this protocol gives us is the language in which to talk about the kind of work women do in the home, but it also gives us the language to push back against the courts, which are giving themselves the discretion, the job of policing what is and what isn't marriage, and therefore what isn't marital property. And I'll leave it there.
Thank you so much. I think there are a number of issues that we need to think through, especially as feminists and feminist activists or activists for women's land and property rights on the continent, and strategize on how to utilize this general comment in a way that it advances women's rights across the board on the continent. So I'm going to move now to question and answer. Please, I want to remind the audience to put in your questions in the Q&A box, and I will get to them. I'm going to start with a question from the audience, and then I have a few questions also that I would like to ask given time. So the first question I think goes to Seodi. What is your take on the suggestion that equity rather than equality should be the driver in dealing with matrimonial property? And this is from Richard. Richard did not, I can't see where Richard is from, but Richard wants to know, what is your take on the suggestion that equity rather than equality should be the driver in dealing with matrimonial property?
Thank you very much. Can you all hear me? Thank you.
Yeah.
So I saw the question, and I think when we go back to the basics in terms of the basics of understanding the notion of gender. I know our gender training that we used to do many years ago. That would be a whole topic on its own: equity versus equality. I think if you look at the argument behind the general comment, it zones in on substantive equality, and which takes into account differentials. Hello?
Yes.
Oh. Okay. So my.
We can hear you, but we lost video. Hello? Would another panelist take up the question while we wait for Seodi to rejoin? So the question is, what is your take on the suggestion that equity rather than equality should be the driver in dealing with matrimonial property? Okay, Seodi is back.
Hear me now?
Yes, we can.
Okay, sorry, you had lost me for a minute. My laptop went dead, so I went to my phone. Okay, so can I go ahead? Can I continue where I was?
Yes, you can. Thank you so much. We understand
okay.
the technological issues that will come up in such a forum.
Okay,
Thank you.
I was so worried. So anyway, as I was saying, that the differentials, the historical differentials, and the experiences of women and men, they, the cultural, economic, social, the socialization and the opportunities that have been presented, between women and men in particular, or the general comment talks about and others. I laughed because it talks about women and others, in that those differentials would then be the determination for intervention. So for me, the whole issue of substantive equality zones in on equity. you know, based on differentials. You can't just say equality because, particularly here in the African context, it doesn't work that way. So for me, to answer the question very quickly, I would think that we should constantly use equity as a tool for you know, determination of property rights.
Thank you so much. The next question, does division of property equally as opposed to equitable distribution help a woman who has an income more than it helps the woman with no formal employment? Jacqueline, can you take this question? Does division of property equally as opposed to equitably help a woman who has an income more than it helps the woman with no formal employment?
Okay, thank you for the question. For me, just looking at the general comment, I would want to use the general comment to respond to that question, is that the courts need to be guided by the issue of substantive equality. So they would determine in each case, what is the substantive equality in this particular issue? That would be on the issue of the low income person. So whatever the low income person has done in the context of supporting the family, whatever the husband has been receiving, if in the event there is a rental income, the husband has been receiving and using the money just for himself, then that comes the issue of equitable distribution. So for me, I would ask that we don't separate the two. So when the court is making a determination, let it look at the substantive equality to make equitable distribution, as opposed to looking at the two in isolation. That's my thought.
Thank you so much. One of the audience members had asked a question, and I responded to that, and I wondered if any of you has more to add to it. Does the general comment contemplate woman-to-woman marriage, both in the contemporary understanding of such marriages and the traditional understanding? And my answer was that we're a little bit on the back foot regarding this question and the general comment, because it still defines marriage as formal and informal unions between men and women of 18 years and above, recognized under any system of law, custom, societal practice, or religion. And I did mention that some national laws have made more progress in defining marriage. And I know some of your countries have taken steps to define marriage much more broadly. There has been pushback in some situations. Other countries have actually moved back to concretize the definition of marriage to only include men and women. But this could definitely take us into another discussion. I wondered if anybody has more to add to this. If not, I think we can move on to the next question. Any other thoughts on definition of marriage? Okay.
Could maybe allow, I would give it within the context of Kenya, the issue of a woman-to-woman marriage, which is essentially non-asexual, is practiced in many countries where women cannot have children. But the issue of property, which the courts have confirmed that form of union is recognized, comes only in succession and inheritance. I've only come across cases under succession and inheritance. I've seen among the participants here is a registrar of marriages in Kenya. Maybe she could also share her thoughts around it, but to the best of my knowledge, under the Marriage Act, it may not really be recognized, but when you go to the law of succession, then they have rights to inherit.
Thank you so much. Sheila, I wondered, given your experience in legislative advocacy, and we've talked a little bit about court discretion and how that plays out in ways that ends up with discriminatory, in some situations, discriminatory decisions against women. I wondered if you could speak a little bit of legislative measures that could actually counter the degree of discretion that the judiciary has in determining distribution of property. The general comment also mentioned special measures. If you could speak a little bit to what types of special measures we should be thinking about.
Wait, the line wasn't really clear. So you're asking about judicial activism, and then the second part?
So I was just going back to your experience.
Hello, Julie?
Yes. Sheila, can you hear me?
Yeah, yeah, I heard the first part where you were asking my views about judicial activism. And then the second part of the question, I couldn't get very well.
Was about special measures. Special measures. What the general comment mentions special measures that need to be put in place, but doesn't really speak to what types of special measures. And I just wanted to get your thoughts on what you think these special measures should look like.
Okay. With regard to judicial activism, I think that, at least for speaking from in Ghana's perspective, I think that the judges in Ghana have been very active in trying to protect women's property rights in several ways. In my presentation, I made mention of a case called Mensa Mensa, where it was a case in which the parties had been married for quite a while. The woman was an illiterate, but very enterprising, and the man was a clerk or something or other in the ministries, etc. Several properties were acquired through the joint efforts, and then the man was claiming that they were all in the man's name only. So the judge just went through this, applying the principle of equity, applying the principle of they even actually quoted the International Association of Women Judges that had done some work on equities, equality, etc., actually quoted it and applied it in that particular case. So they can use it very constructively, okay? Even on the issue of cohabitees, which I mentioned and said, when it comes to legislation, most people don't want to see it because in Ghana too, when it comes to people who are not married, who are just cohabitees, they don't really have any rights. But when it comes to intestacy, inheritance, their children can benefit, but they cannot, okay? So we have a number of cases where cohabitees have actually taken cases to court. There was one, which is a very old case in the early 1980s, a woman farmer who was in a relationship with a man, and they were farming a cocoa farm. Cocoa farms in Ghana are commercial in nature. And usually it takes about 8 years for the cocoa to start bearing fruits. They lived together, had 2 children. In the 7th year, the man said he didn't like her anymore, so she should leave. So she went to court, and they called evidence. It was established that, as customary law, cohabitation is not recognized, and that the ordinance is also not recognized. But the court said that the nature of the relationship was such that it should be regarded as a business relationship, and it would be inequitable for one person to benefit out of, a common joint venture. And in her pleadings, she had asked for 1/3 of the farm, and the court gave it to her. In another case, the woman, there were also 2 unmarried people. The woman asked for 50%, was able to establish that she was in a joint venture with the person, and the court also gave her 50%. So the courts have actually been very creative. The only problem is that sometimes some of them do not follow some of the existing precedents, and sometimes take up back and forward. But I think that we have a lot of judicial activism in Ghana. Now, in terms of in the joint comments, reference was made to some special measures. Some of the ones I can think of was some of the ones I mentioned we had, based on research we had done, put into the Property Rights of Spouses Bill we sought to push in Ghana. One of them was that, yes, all properties which are jointly acquired in the course of the marriage are presumed to be jointly owned. But there was also provision made for separate property. And the difference was that room was made for the 2 parties to agree in written form that maybe for this particular property, acquiring it alone, it's got, you're not making any contribution to it, then that could be held as still separate property. The law also indicated that properties which were sort of inherited in the course of a marriage could also not be put into that basket. So the special measures, yes, could be put in place. And I think another key special measure which was put into the law was the issue of prenuptial agreements, which is not a common feature in Ghana. So the law made provision for the parties themselves to come up with their own prenuptial agreements. Of course, we should not touch on issues to do with custody, etc., just on property issues in terms of how they would do it. And special measures were also put in place to ensure that people's rights were not abused. You know, where you can establish that there was duress, etc., etc. It made room for the documents to be sworn before the commissioner for oaths, etc., etc., etc. So for me, it's possible to come up with some creative measures that would be aimed at protecting people's property rights, as well as more vulnerable people. You recall I also indicated the special provisions we put on people in polygamous marriages and how there was a need to also find a way in which there would be equity between the woman and the man, and then amongst the women themselves as well. Yeah, so I think that's, you could think very creatively of other measures that could help protect women's property rights in particular. I think that the last one I'd like to mention was on the issue of contribution. So the list, there was a long list in the interpretation section in terms of what is contribution. So it talks about working in a person's farm. So it's considered the non-middle class person if you work in a farm together with a spouse. If you forego a promotion, sometimes when women are promoted and they are transferred somewhere because their spouses will not move, they will not do it. They will not take the promotion and earn a better salary. If you, there were several scenarios that were thought of, which were documented as contribution. I thought that was also very creative and could be one of the special measures we could all consider. Thank you.
Thank you so much. I just thought of a glaring example. I think it's the Kenya case where Parliament there's a discussion around the membership formation of Parliament, and the special measure that was taken on the constitution of Parliament, what percentage should be woman and what percentage should be man, and this is to ensure that policies that are enacted from this body reflect women's views as well as men's views. So in some senses, I think in some sense, for most countries, at least there's that special measure that's put in place and can benefit how legislation is actually designed. There was something I wanted to mention. Clarice mentioned in the chat about the big elephant in the room. And I think, Ambreena, you talked a little bit about that. She talked about women who have properties in their name. Where do we find this balance? I don't know if you can take that question.
Juliana, you broke up there just as you were setting out the question. Would you do it again?
Oh, sorry about that. So Clarice is asking about women who have properties in their name, as you mentioned, that where do we find the balance that protects all women irrespective of economic status? So I think she's alluding to what you mentioned about these women being, distanced from the movement, the current movement, because either they're not sure about what would happen to the property that they've acquired, or feel like they're not at the same level as maybe women in rural areas or women with low socioeconomic status. So how do we bring everybody into the fold? I think this question actually needs some clarity, because people think that the more you have, the more you're going to be impacted by equitable distribution. And I don't necessarily see that as the case. Sorry for preempting your answer. And you can totally
No, you're absolutely right. No, you're completely right. You're completely right. There are a few reasons, right? So if you're a propertied woman in your own right and you've acquired property, then actually equitable distribution is the last thing you want. And the chances are that, if you're smart enough to worked your way into all of this property, you're also smart enough to make sure you get the legal advice, etc., to protect your property. These are not the women I'm worried about, quite frankly. You know, propertied women who are capable of looking after their own interests. That's not where our work should be and our energy should be expended. What we need to be thinking about is women who are vulnerable because, for example, a piece of land is really their only, the only access they have to some kind of productive land, right? Or some kind of subsistence, some kind of quality of life. It's those women who are most vulnerable. It's those women whose interests in equitable distribution we should be thinking of, where it's likely that they have done massive amounts of unrecognized reproductive labor. Again, this is why I say we need to think in class terms, and it's not always comfortable to do so. A woman who has a great deal of land in her own right has probably also got the capacity, has probably had over the years the capacity to bring in paid labor to support her. So it's those women who will have domestic labor, for example, in their home. A woman who is less well off will be the one who has put in massive amounts of her own time in both production and reproduction, because she doesn't have the ability to buy in the extra labor to support her. She simply does it all. And it's those women that I think we need to be thinking about. And it's those women also who are very vulnerable to the whole issue of mortgages and consent that I was mentioning. We know from experience that middle-class women and well-off women know how to acquire legal advice, understand the mechanism of a mortgage, understand what it is as an instrument, know how to go and get advice about it, know how to resist any pressure to consent to financial transactions of that sort. Well, less well-off women don't. So I would certainly say, you know, we have a certain amount of energy to expend. Let's not waste it on in places where we don't necessarily need to make an intervention.
Thank you. We will be wrapping up soon in the next 10 minutes. I have a quick question I want to throw out before I sum everything up. What is, for any panelist who's interested in taking this, what is your prediction on the general comment? Like what will happen? How will it be used in the next 5 years down the line? How do you see this step? How do you see this being used over the next 5 years? Where do you think we are going to be in the next 5 years? I want to end with an optimistic, uplifting thought. That there's the light at the end of the tunnel. I
can take that one.
Okay, awesome.
Yeah,
Thanks,
yes. You know, when you look at the fights we've had in the last couple of years, not couple, in the last 20 years or plus, nothing has come on a silver platter. You know, when I worked in Rosa, I thought everybody was talking about women's rights, everyone, until I now moved on into a space which is basically, you know, no one talks about gender. That's when I realized that the conversation that we have, nobody else is having, it's us pushing. So for me, yes, the current, the general comment and its interpretation, and therefore, you know, its diffusion into our courts will only happen when we push for it to happen. When we take enough test cases and we create a social movement. Now, these days, it's easier with the social media, you know, showing how judges are using this. That's when it will become viral. So the work is still ours. You know, we are the ones who continue to educate the justice system on what women need and what justice is. Therefore, it won't come, in my opinion, automatically. It's about how we advocate, and I think using test cases continuously, putting the debate alive continuously, and yeah, you know, really sending out precedents continuously. That's my take on it.
Thank you so much. Does anybody else want to add to that?
Okay, thank you, Juliana, for the question. I would also just go with what my senior Seodi has said. For me, law reform may be a tall order for now because the Act, the Material Property Act, is about 7 years old. So that may be a path not many people, including the parliamentarians, would want to use. It's also an election year in 2 years' time, so law reform not ideal. So I would just hope that we use this general comment to advance litigation. And for Kenya, we can start with the Supreme Court case. The Supreme Court case is expected to set up clear principles on what needs to be done on issues of distribution and issues of equality. So I think we can use this, and that can happen within a span of 5 years. And before we even have the Supreme Court make a determination on the matter before it, lawyers in the House can use this general comment to advance in line with Article 2 of our Constitution. So let's use the courts. We have used as Kenya the courts for over 50 years to advance matrimonial property cases since independence up to 2013. So let's still use the courts to advance these general comments. And maybe in my parting shot, as Martin Luther said, we are not makers of history. We are made out of history. Let's use these general comments to ensure that the history that we found is better when it comes to issues of women land rights. Thank you.
Thank you so much. Anybody else wants to add? Then, if no one else, I would like to close by reading a quote. I think it kind of moves, it supports what Seodi and Jacqueline have said. The Commissioner of the African Commission on Human and People's Rights and Special Rapporteur on the Rights of Women in Africa, Justice Lucy Aswagbo, was quoted saying, "Adopting a legal instrument is one thing, but ratifying and implementing its content requires the same tireless women and men of the continent who believe in its potential to pick up their advocacy tools and convince state parties to deliver on their commitments." I believe this calls on all of us to act and to continue acting, right? Thank you. I want to thank the audience for being here, for being with us throughout, and for your insightful comments. We really appreciate it. I wanted to thank the panelists for all being present. You are 100%, and I really appreciate that. And I think we shared some really valuable information with the audience. I want to call out to the audience that if you're interested in following up on specific details that were mentioned during the panelists, Tiffany has shared, or Sibongile has shared Tiffany's email on the chat function. Please copy it, have that ready, reach out to her, and she can follow up with any of the panelists to get clarification or get added resources that you might need in either the work that you're doing or research that you're embarking on. Thank you everybody for joining. We've come to the close, and I think this was a great session. Thank you.
Thank you. Bye-bye. Yeah.
Bye everyone.
Bye.
Bye. It was nice having you all.